Welcome back to the deep dive. If you're listening, you're probably keen on staying informed, especially on crucial constitutional matters.
Which is vital, particularly if you're prepping for the UPSC exams.
Exactly. And today we're diving deep into the Supreme Court's recent judgment concerning Article 143. This all came about because of that issue with the Tamil Nadu Governor and clearing bills.
It's a really significant development touching on how the whole constitutional machinery is supposed to work.
For sure. So our mission today, pull out the key insights from this judgment. We're mainly looking at coverage from the Hindu and really clarify what it means.
We want to give you the context, the core arguments, and the implications.
And for the UPSC folks listening, this is gold. We're talking separation of powers, the judiciary's role, Articles 143, 200, the real nitty-gritty.
Stuff that makes a difference in your answers, definitely.
Right. Let's jump in. What actually sparked this whole thing? What was the immediate trigger?
It was, as you mentioned, the situation in Tamil Nadu. There was a significant delay, a logjam really, with the governor not acting on bills passed by the state legislature.
Bills were just sitting there.
Pretty much. And that delay, that inaction, is what pushed the issue before the Supreme Court, leading to these important directives.
Okay, so the court stepped in. What were the main things they directed?
Well, there were a few key takeaways. First, they emphasized the need for a reasonable time frame for governors and also the president to act on bills.
A time frame? Did they specify how long?
The Hindu didn't report a specific number of days, but the court definitely stressed that there needs to be timely action. No more indefinite waiting periods, basically. That alone is a big shift.
Yeah, you can see how endless delays could just paralyze a state government. What else?
The second big point was about the court's own role. Specifically, when a governor reserves a bill for the president because they think it might be unconstitutional.
So when the governor flags a constitutional issue and sends it up the chain?
Exactly. The Supreme Court made it very clear that it has a role to play then. It's not just an executive decision between the governor and the president.
Okay, that's interesting. So if a governor that reserves a bill citing constitutionality concerns, what did the court say should happen?
This is probably the crux of it. The court strongly suggested using the term ought to, which carries significant weight, that the president should then use Article 143.
Use Article 143 to do what?
To seek the Supreme Court's advisory opinion on the bill's constitutionality. It's like the court saying, if there's a constitutional doubt raised, ask us.
Okay, let's pause there. Article 143, remind us, what power does that actually give the president?
Fundamentally, Article 143 allows the president to refer significant questions of law or fact to the Supreme Court for its opinion. It's a way for the executive to get expert legal guidance.
But it's just an opinion, right? Advisory.
Precisely. That's a key point the court also reiterated. The opinion given under 143 isn't legally binding like a judgment in a case.
So it's advice. How did the court square that with saying the president ought to seek it? How did they see their role here?
They explained that even though it's advisory, when a bill is reserved under Article 200, specifically because of perceived unconstitutionality.
Article 200 being the governor's options, assent, withhold, reserve.
Yes. When it's reserved for that constitutional reason, the president seeking the court's opinion under 143 becomes, well, almost a duty in practice.
A practical duty, even if not strictly legal.
Kind of. The court stressed that its advisory opinion holds immense persuasive value. It should ordinarily be accepted by both the legislature and the executive.
So while technically not forced to follow it, ignoring the Supreme Court's constitutional take would be unusual.
Highly unusual and likely problematic. The court emphasized that the non-binding nature doesn't lessen the importance of its reasoning or the constitutional principles it lays out.
Did they mention any past cases to back this up?
They did. They brought up the 1978 Special Courts Bill case.
Okay, the Special Courts Bill case. How is that relevant here?
That case established the idea that judicial review, or at least judicial input, doesn't have to wait until after a law is passed.
So courts can offer opinions even before a bill becomes law.
Exactly. The 1978 judgment basically said constitutional courts aren't barred from giving suggestions or opinions pre-enactment. The idea is that this can actually prevent future legal battles.
A sort of constitutional health check up front.
You could put it that way. It saves time, resources, and avoids having potentially unconstitutional laws on the books, even temporarily.
Makes sense. And the court also talked about the broader value of this kind of judicial scrutiny, didn't they?
Yes, they highlighted a few things. One, it stops patently unconstitutional bills, which protects public money. Think about the cost of implementing and then defending a bad law.
Good point.
2, it actually respects the legislature by offering this review before enactment, potentially preventing their work from being struck down later.
And you mentioned fairness earlier. How does that fit in?
Well, the court suggested that involving the SBSC via Article 143 acts as a check against potential bias, maybe even political motives, when the central government is reviewing a state bill reserved by the governor. It promotes impartiality.
So it's also about checks and balances between the center and states.
Definitely plays into that, which leads to another point the court made about limiting executive power in this specific area.
Right, the idea of executive overreach. What was the court's take?
They were quite firm. The judgment states that the union executive, the central government, shouldn't be the one making the final call on whether a state bill is constitutional or not. That's not its role.
So the executive can't act like a court.
Precisely. When a bill is reserved specifically on constitutional grounds, the executive needs to show restraint. Deciding constitutionality is the job of the courts, specifically the constitutional courts.
Clear separation of functions there. But the court also talked about its own restraint, didn't it? What are the limits on its role under Article 143?
Yes, that's crucial. Judicial restraint. The court made it clear its examination under Article 143 sticks strictly to legal or constitutional questions.
No policy advice.
No, it won't get involved in purely policy matters or political debates. They mention the political thicket doctrine areas the judiciary generally stays out of.
Can you give an example of something they wouldn't give an opinion on?
Sure. They cited the example of the president deciding whether to assent to a state law that might conflict with a central law under Article 254, Fav 2. That involves policy, balancing federal and state interests.
So that's a decision for the president, not something the court would advise on under 143.
Correct. That falls into the executive legislative domain. The court draws a line there.
Okay, that clarifies the boundaries. Now, why did the court feel it was so necessary for the president to seek its opinion in these cases?
They pointed out a kind of gap in the system. There's no similar mechanism at the state level for a governor to directly ask a high court, say, if a bill is constitutional before signing it.
Really? No state-level advisory jurisdiction like that?
Not in the same way for pending legislation. So the court argued the only route for getting a judicial view on a state bill's constitutionality before it becomes law is this. Governor reserved for president. President consults the Supreme Court under Article 143.
So this process fills that structural gap.
That seems to be the court's reasoning. It provides that pre-enactment constitutional check.
Did they look at how other countries handle this? You mentioned international examples.
Yes, Justice Pardawalla's concurring opinion mentioned a couple. Sri Lanka's constitution, for instance, has a process where the governor refers a bill to the president, who must consult their Supreme Court. If the court says it's okay, the governor must assent.
Interesting. Mandatory consultation and assent if cleared? Any others?
The Republic of Kiribati was also mentioned. Their head of state can only withhold assent for constitutional reasons. If Parliament passes it again, the head state either refers it to the High Court or has to assent if it's deemed constitutional.
So other places do have formal pre-enactment constitutional checks involving the judiciary.
It shows it's not an entirely novel idea, this kind of review mechanism.
And haven't our own commissions like Sarkaria and Punchy touched on this?
Absolutely. Both the Sarkaria and Punchy commissions recommended that the president should use Article 143 to seek the SC's opinion if a reserve bill seems clearly unconstitutional.
So past expert bodies agree with the court's current stance.
They do. They saw Article 201, the provision about reserve bills, partly as a way to enable this kind of pre-enactment scrutiny to protect democratic principles.
Okay, pulling it all together, it seems the court is really trying to shape how Article 143 is used, making it a more active part of the process.
I think that's fair to say. They're setting expectations about timeframes for the president, strongly pushing for consultation on constitutional issues.
But still maintaining that line about not getting into policy.
Exactly. It's proactive, but within defined limits. They're expanding the use of 143 in this specific context while respecting the separation of powers regarding political or policy questions.
So final thoughts. What's the big picture takeaway from this judgment?
I'd say it clarifies the framework. It defines the roles governor, president, Supreme Court more clearly when a state bill faces constitutional questions before becoming law.
And it promotes that pre-enactment check.
Yes, promoting a check to uphold constitutional integrity while trying to balance that proactivity with judicial restraint, avoiding stepping into purely executive or political territory.
This has been really clarifying. A complex issue, but vital, especially as we keep saying for UPSC aspirants. Understanding Article 143's role now seems even more critical.
Without a doubt. For anyone preparing, understanding these nuances, federalism, judicial review, legislative process, the roles of the governor and president, this judgment touches on all of it. It's prime material for mains and potentially prelims, too.
Definitely food for thought. And speaking of thoughts, we'd love to hear yours. If you have questions about Article 143 or this judgment, drop them in the comments.
Please do.
And if this deep dive helped you, please like and subscribe. We'll keep bringing you analyses of current affairs relevant to your prep. Our main source today, remember, was The Hindu.
And maybe one last thing to chew on, particularly for the aspirants. How might this judgment really shift the legislative power balance between the union and the states? And practically speaking, what challenges could arise from trying to implement that suggested time frame for presidential action?
Great questions to ponder. Thanks for tuning in to the deep dive.